number 3, Taylor versus 72A Realty Associates. One moment, counsel. Good afternoon, counsel.
Good afternoon, Your Honor. May it please the court, my name is Joel Zimberg, and I represent the defendant appellant 72A Realty Associates, and I respectfully reserve 1.5 minutes for rebuttal.
You may.
This court, there's no question that the legislature can change its mind. It can decide that they think their rents prior to 4 years are incorrect, and they don't want those rents counted. They want that to be corrected. The question, and the narrow question that we're dealing with today, is can they apply that change consistent with due process in this narrow set of cases where all these J51 cases, where all the owners did, and nothing wrong other than rely on the relevant administrative agency's guidance that was in place unchanged, unchallenged for over a decade.
So you're here on a certified question, correct?
Excuse me?
You're here on a certified question, yes?
No, we're here on the question is, was it correctly decided?
I think what Judge Wilson's getting at, the way you got here is that the appellate division certified a question as to the propriety of its order.
You have a non-final
Because it's a non-final appeal.
Right?
That is correct.
And the appellate division certified a question to us, otherwise we wouldn't have jurisdiction to hear your appeal, is that right?
Right.
Okay, you're familiar with the McMaster case from this court from 1925?
No, Your Honor, this court sent out a letter requesting
I understand.
that the parties in all of the cases deal with the question of the HSTPA should be applied. So
Okay.
it was my understanding that the court was soliciting this.
Are you familiar with the McMaster case?
No, Your Honor.
Okay, then I'll ask someone else.
Okay. If we're going to apply this court's decision in James Square Associates, where they set out a 3-factor test to see whether due process, commensurate with due process, you could apply a new statute retroactively, you cannot apply the HSTPA to this.
But why should we do that in a non-tax case?
Because the tax cases are generally where this court and the U.S. Supreme Court have said it's a more flexible application to retroactive cases because you're trying
I understand why you would want us to apply it, but is...
No, I understand, Your Honor, but it's those particular cases where this court and the U.S. Supreme Court have said we're going to be more flexible in trying. So if you can't meet the test in a tax case, the James Square case, you can't meet it anywhere. And I think the most important part, the third factor in James Square, is there a public purpose for a retroactive application? And I think if you look at the legislative record, which we have, and the bill jacket just came out yesterday, we've scoured it, you cannot find any expression of a particular reason why the HSTPA, this one particular part of the HSTPA dealing with overcharges, should be applied to pending cases. It's very much like what this court said in James Square. The state fails to set forth...
Do they actually have to articulate it in the statute or in the legislative history, or is it up to the court to figure out if there's any conceivable rational basis for applying it retroactively?
Well, they have to do it, Your Honor, because, for example, as Judge Fahey pointed out in 1997, there were amendments, but the difference is in 1997, this court there were legislative memoranda that dealt with the reasons they were amending the statute, and those, I referred to those in my brief at pages 5 and 6. There was legislative memoranda.
Usually in our analysis, we go to legislative history after we read the law and say that we need to look beyond it. If the law is sufficient in and of itself on its face, we may not need to do that. And I think you're back to two things, whether the James Square factors would even apply, whether this is actually a taking, or whether because it seems to me that the more controversial issue is not the 4 or the 6 year question, but really the question of what's been called the evidentiary rule is and whether it applies. And that, to me, seems to be an analysis that's entirely outside of the James Square analysis. That's the difficulty I'm having with your argument. So this evidentiary rule, I don't see did they have a rational basis to do it? Was it proper? Okay, that's a fair argument. But whether or not it involves, and even if it involves substantive due process, that's a fair argument. But the James Square factors don't apply in that context to an evidentiary statutory rule. That would be how I would view it from the other side.
Yeah, but Your Honor, the HSDPA is not merely an evidentiary rule.
I understand in and of itself it's not, but no, we're talking about 213A, and you get right down to the core of 213A. It's two things. It's expanding the statute of limitations from 4 to 6 years, number one, and number two, it's saying that you can use the evidence beyond the 4 years.
But it's also changing the length of time you can collect penalties for the treble damages. It's changing the discretionary attorney's fees to a mandatory attorney's fees.
Right, focus in for me on the evidentiary question, okay?
The going back from 4.
You can go beyond the 4 years.
Well, the point is, I still think it applies. There's no question you can change that.
Tell me how that's a violation of your substantive due process rights, because
Aren't you saying
that's the way I'm sorry.
Because this case has been pending for 6-7 years already. And that fact goes back to 2013, when the defendant became aware that the tenants in this case, because of the decision in Lucas, had to be considered rent-stabilized tenants. It said, we need to figure out if there's an overcharge. It looked back 4 years, said no overcharge, it gave them a lease. Same thing in 2014 when the case started. It determined no overcharge, no need to adjust the rent. Now, because of this evidentiary change, the owner is looking at 7 additional years of overcharges that are going to be we're going to have the addition of 9% statutory interest, which I know the court can't change, but the reality is it's 4 times the market rate. It could have avoided litigation back in 2013 had it had any kind of inkling, any kind of forewarning, which is one of the James Square factors that something was going to happen. But now it couldn't avoid that, and now it's stuck with litigation and mandatory attorney's fees, which is yet another reason that retroactive penalties.
There's several of these cases, obviously, and I may have my facts mixed up. Is this the one where you went ahead and calculated what you thought might or might not be owed and sent a check?
No, Your Honor.
That's a different one. Okay.
This is a case. This is a case, and has never been disputed, where if you use the 4-year rule as existed in 2013 and as existed in 2014, there were no overcharges. Therefore, there's no treble damages, no attorney's fees. What happens is if you apply the HSTPA, it suddenly goes from a case with no overcharges to a case with overcharges, mandatory attorney's fees, expanded and more severe liability for treble damages. And that, too, is I cited multiple cases.
That's an attempt to correct an error to get to the lawful base date rent and moving forward. Why doesn't that serve a public purpose? Let's assume for one moment that we're agreeing with you on the applicable test. I'm very hard pressed to understand why there's no public purpose served.
I think what you're asking, Your Honor, is why should we apply a rent that we think was incorrect? Because after all, after Roberts, we know they shouldn't have deregulated the apartments. Now you charge market rate rents. But the point is, there was also a 4-year rule that was set out in the law.
No. I'm going back to your test. Your test is one that you claim this third factor about the public purpose is not met because there's no public purpose in retroactive application. So my question to you is, why isn't that corrective effort to ensure you have a lawful rent moving forward in service of a public purpose?
Well, Your Honor, that has not been articulated, first of all, by the legislature. Second of all, there's nothing in application. That's true for prospective, what you just enunciated. But there's nothing.
Well, why isn't it true for retro, is what I'm asking you.
Because we apply a different standard for retroactive than we do prospective. Okay. The fact that something might work for prospective does not mean it applies consistent with due process for retroactive.
I mean, the legislature wanting to ensure that the regulated rents are correct and lawful in accordance with the law from the base, a lawful base rent moving forward doesn't serve a public purpose.
Your Honor, I don't know what their purpose is.
Let's assume for one moment it's the one that I have articulated.
Right.
Why doesn't that serve a public purpose? I'm working with the standard you are advocating.
I'm working because three basic reasons. Because the law as it existed going back many years,
Yes.
unchanged, and at the time, 2000 when the deregulation occurred, 2013, 2014, 2017 when this case was decided by the appellate division, was the 4-year rule. And this was a rule that the defendant and others relied upon to its detriment, as I just tried to sketch out. It was a rule that the legislature set out as a compromise. I think it's going, what Judge Rivera said, the idea was to give repose. There was a point in time.
Judge Garcia, but
I didn't say that.
but let me just take a step back for a second. You're arguing at its core substantive due process, right?
Yes.
Okay. So let's go back to the Supreme Court cases, United States Supreme Court. They've stated that the constitutional impediments to retroactive civil legislation are now modest, quoting from Landgraf. It's in the 90s, I forget when. Absent a violation of a specific constitutional provision, the potential unfairness of retroactive civil legislation is not a sufficient reason for a court to fail to give a statute its intended scope. And the way I understand your argument is it's not fair.
No, Your Honor.
Let me just finish. The fairness argument can go both ways. And I think that you can make a decent argument on that, and we can make a decent argument against it. That's the problem with these concepts. They tend to be a little slippery. But what the United States Supreme Court has understand, as I read the cases that have come out there, is that specifically, if there's a specific statutory or there's a specific constitutional violation of a particular provision, then you can consider it. Otherwise, the legislature can do what they feel policy requires.
Your Honor, as set out by this court in American Economy, I think citing...
Which I wrote, so I'm familiar with it.
Citing Landgraf, it said there has to be a rational relationship between the policy...
Well, as Judge Rivera has made clear, there's certainly a rational relationship. It's irrational if you're on the taking end, and it's rational if you're on the receiving end. That's how I'd characterize this particular rationality argument.
But they have not set out any argument, and in fact, they have not set out what they were trying to accomplish.
Forgetting what they haven't set out, forgetting what they haven't set out, tell me why you say it's irrational.
I'm saying it's not a question of rational or irrational. I'm saying this will not keep any of the tenants in these cases from being evicted. It won't increase the stock of affordable housing. It won't meet with the goals of the rent stabilization law that this court set out in Santiago Monteverde, which was to preserve housing for low and working class people. It will not do that. These are all wealthy individuals. The defendants in this, the plaintiffs in this case are Oscar-winning directors.
Is there anything in the record about their income or assets?
No, there's nothing in the other than that statement was made and never denied, Your Honor. And
which statement?
And
that they won an Oscar?
That they've won Oscars, and I think they've
So
demonstrated.
how much can you sell an Oscar for on the open market?
No, Your Honor, I think the court can take judicial notice that Oscar-winning screenwriters can command large fees.
Counsel, getting back to Judge Fahey's question to you about, is this more than just it's unfair to the owner's argument? Is this an argument about expanding liability to the owner based on conduct that was previously permitted? Is that where?
As I was trying to express before, Your Honor, it's subjecting retroactively this owner to penalties that did not exist before. And there are a number of cases that say that that is not consistent with due process. And I outlined what those penalties are. Mandatory attorney's fees. It's changing this case from one where there were no overcharges to one where there are overcharges. And for that reason alone, it should be scrutinized in this particular case. That's a distinction between this case and the other cases.
Are you also arguing that when we look at this, we have to look at the look-back rule in particular in relation to these other aspects of the statute. We don't look at it in isolation.
Correct.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. I'm Robert Sokolsky. I'm here with my wife and partner, Daphne Zakaria. Sokolsky and Zakaria will represent the plaintiffs plaintiffs in the action below and respondents on appeal. If I could get to Your Honor's point about the public purpose first, if you don't mind. There's a public purpose in this in order to go back retroactively, and I'm very reserved with using the word even retroactive. The tenants are still paying the price of the landlord's unlawful conduct today. This isn't something where you have a mistake and there's no impact coming into today. It all comes into today because whatever overcharges the landlord charged in the past get added in and compounded every time that the lease is renewed. So I don't necessarily even look at this as a retroactive situation. This is prospective. The tenant today is still paying that. So yeah, that's why I don't really perform much of a retroactivity analysis on it, and that's why I say it supports the public interest, because your Honor's question about that was correct. It restores what the rent would be. If I overcharge somebody my hourly fee by mistake for 3 years, and that was brought to my attention, what would I do about it? I'd go back to 3 years. I'd figure out how much I overcharged for every hour or however I billed, and I would reimburse someone, because that's the fair thing to do, isn't it? These cases, Justice...
But isn't the question whether every lawyer in that situation would be legally required to do that? When they were under a mistake about... They were under a mistake about what the agreement had been, say, for example, as to what the hourly rate was.
Right.
So, oh, gee, I thought we had my understanding was this. Maybe it's before retainer agreements in writing or whatever, and the tenant comes and says, no, your understanding was wrong, and here I have a recording of you telling me it was that.
Yeah.
Okay, so...
There would absolutely be a legal requirement, right? Because you have an agreement, you have a set amount of hourly fee, and you've overbilled on that, and they can certainly come after you for breach of contract and for the overpayment, and they can get it back the same way that it happened here.
So
right?
Well, it's different to this extent because it's a highly regulated area. There are always changes.
There's always changes.
Yes.
One change that has never... I'm sorry.
No.
One change that has never, ever been made since the registration requirements were started in 1984 is that if you fail to register the apartment and it's rent stabilized, you don't get a rent increase, period. You don't get one.
How is it fair to say, okay, you filed these registrations as long as the apartment was required to do so because, it's rent stabilized, putting aside J51, putting aside those problems. And then at some point, it becomes decontrolled, whether it hits the 2,000 limit, whether it's a non-primary resident, I don't know, it becomes decontrolled. And then to say, so now the landlord is no longer required to file the registrations. But then a couple more years go by and somebody who comes into the apartment says, you know what, it never should have been decontrolled for whatever reason. And I'm going to go back to that very first rent registration.
Right.
That's the problem that I'm having.
Right. Okay. Let me try and explain it two ways. First of all, the only thing that you're doing is restoring the proper legal rent to the apartment. If you go, no matter how far you go back, if you go back until you hit a reliable registration, the only thing that you're doing is to restore the lawful rent to the apartment.
You're imposing treble damages, attorney's fees, and a whole lot of other things based on records that may not exist because you didn't think you were required to register, and you didn't think you were required to keep those records.
And the agency told you you didn't have to.
Right.
And I'm sorry, so that's point 2, okay? I gave you half the point. Point 2 is, on a proper showing, that wasn't made here. Because, and I want to point that out. I mean, we are patently non-final. We have a denial of a summary judgment motion, a granting of the tenant's cross motion just for a finding of stabilization. However, which the defendants fought. I mean, we're not just talking about straightening out the rent here. This landlord fought stabilization, tooth and nail, even after Roberts. This is not.
So this is the one where there was a delay of about 2 years or so?
Well, even if
the registration?
Yeah, but even for Roberts came out in 2009. In this case, I mean, the court's own fact pattern also recalls that the landlord didn't give a stabilized lease until 2013.
Their explanation, I guess, is that they had litigation with Lucas and they were waiting to see how that came out before deciding what they had to do.
Absolutely. And you know what? And if you make a bet on the law and you lose, you pay the price. That's what happens.
Counsel, could we go back to something you were saying earlier, which seemed to be an analogy to ongoing damages, right? There was this problem that happened a long time ago, and it continues to have an effect today. And you breach a contract, the damages that result from that breach continue. But that goes back to this, the problem I'm having with this is, you breach a contract, you have a certain amount of time to bring that claim, 6 years, let's say. Here you don't have any time limit to bring the claim. So I know I have one of these claims now, but I don't think it's a good tax year for me. So let's say I wait, because I know it's ongoing damages, and then I bring it when it's convenient for me, and I get 6 years. I get the 6 years of my choosing effect. Isn't that different than a type of ongoing damages analysis for a contract claim?
No,
because a contract claim I have 6 years.
No, because in nearly all of these cases, and by the way, yeah, I just wanted to point out too, and I know Your Honor knows this, but the damages are limited to 6 years. This isn't unlimited damages. What you're talking about is how far can you go back in order to determine what the legal rent should be.
Whenever you want. Like, there's no limit on when you can bring it under your theory. Look, I've got 6 years of damage.
Because it's an ongoing violation. In all of these cases, you're going to see this case too. This record, they went off the tracks in like 2002. When they got sued, they backfiled 4 years of registrations, only 4 years of them. And this is a 2014 index number. They went from 2010 to 2014 and filed back. They didn't correct anything.
Well, didn't they try to file the prior period and your clients objected? No?
I don't think that's
okay.
in the record at all. But getting back to Your Honor's point, what do we have? On a proper showing, and I'm denying that happened here for that reason, but in a proper showing, that's what treble damages are about, right? If they show that they honestly relied upon DHCR's advice and deregulated a unit, by the way, while every city regulation that they got the J51 tax benefits under, all of them say those units remain stabilized for at least as long as the benefit period, okay? So I find some of this a little dubious. I think that they took the rosy interpretation because it made them more money. And they took that chance, Your Honor, but they lost. They were wrong. They violated the law. Now they're looking to violate more laws because they're saying, well, we didn't register because we didn't think we had to, right? So, you know, I think that on a proper showing, I think that they can be denied treble damages because they're showing that it's not willful, and that's how the law works. All they are doing is to restore the rent to what it would have been had they not violated the law.
Let me ask you this. What is the purpose of treble damages, generally?
The purpose of treble damages generally is a penalty. It's penalty and deterrence.
Is there any claim-inducing function?
Sorry?
Is there any claim-inducing function of treble damages?
There might be. I would posit that attorney's fees are much more claim-inducing than treble damages.
Okay, so let me ask, let's stick with treble damages for a second. Given that the actions here have already happened, and let's just assume that the change in the legislation changes in a way that is adverse to your clients, adverse to his clients, the treble damage provisions, how does that serve either the deterrence or I'm not sure it's any different, the deterrence or the penalty purpose? That is, the actions have already taken place. So why retroactively trebling the damages or changing the basis on which you can get treble damages, why does that serve those purposes?
Well, for deterrence.
Deterring somebody else, you mean?
Deterring someone else from following the law.
That's fine. So why is there a difference in deterring somebody else between prospective and retrospective application of the treble damages in the new statute?
I'm not sure I understand the question.
Okay, we'll move to something else.
Okay.
Well, if I may try, I think the point is if you've already committed the act, you're not going to be deterred because you've already done that. So why not? Excuse me, so wouldn't that mean that treble damages retroactively, of course, should be viewed differently than treble damages prospectively?
Well,
if all you're focused on is on deterrence.
But it's general deterrence. It's also individual deterrence, because you might have a landlord that's got 60 units or 100 units. Okay, the landlord in this case didn't come up and say, "Oh, Mr. Taylor, you're stabilized." Even when Lucas was being litigated, they didn't come up to Mr. Taylor and say, "You're stabilized," when Roberts was determined. And I see my time is up. If I could just make one point.
You may, one point.
Thank you. The point 3 of my brief that I talk about the rent freeze is absolutely where we are now, because what the legislation is doing is saying you have to go back to a reliable rent registration, okay, at least 6 years ago, could be unlimited years ago, okay, and then come forward. And we see that the courts now that are dealing with this in the lower courts, there was one Gold Rivka case that the amicus cited in their brief, and I also put it in my letter of October 16th. The lower court stops and says, well, wait a second. They didn't register anyway. Rent's frozen. That's how it should be. The only reason that we disagree with Justice Gish's decision and the appellate division in this is because they added in increases that were not lawful rent increases because the landlord failed to file registrations.
Thank you, counsel.
Thank you very much, Your Honors.
Counsel?
Just to correct some misconceptions and misstatements about what the record is in this case. As Your Honor pointed out, the owner did not know until Lucas was decided if the plaintiffs here had to be considered stabilized. But as soon as Lucas was decided, it provided a stabilized lease, and then in the next available time, registered the apartment. It attempted to register the apartment for the entire period of time, and as you said, the DHCR said for some of those years you needed an administrative determination, which the plaintiffs opposed, and that was the reason that DHCR cited for not approving the administrative determination and registering the rents. Vis-a-vis Lucas, which I think Your Honor, I don't want to mangle your name again, so I'm not going to bother. But you did ask the question about whether stabilization would continue at the end of a J51 period. And there was a misstatement during the previous case. 26504C creates really two classes. It said that if you were getting if you're stabilized by virtue of receiving a J51, you had to put those notices in the lease. However, if you were not, and this is clarified both in Gersten and in the Lucas case, If you were not, you did not need to put that J51.
In other words,
notice.
you were stabilized anyway, regardless of the J51.
Correct, and if you were stabilized, as in this case, because you had an older building and you were subject to the earlier laws. And that was not
So
clear.
just so I'm clear, so you're stabilized because of both things, essentially, the older building and J51?
Correct, correct.
And you didn't need the riders in that
You
case?
do not need the rider. That's actually stated in Lucas. In fact, that turned around, in Lucas, the two lower courts said
Okay.
you remain stabilized because the notice wasn't there. The Lucas Appellate Division decision said, no, they were wrong. Relying on Gersten, you did not need the notice.
so
But then
under
it
the-
said you stay stabilized because you improperly,
Right,
quote,
so it's
unquote.
not based on the filing of the notice or not. It's based on kind of a...
It's based
because
on
of-
nothing, Your Honor.
It's based on their
There was no
perception of
citation to a statute, a regulation, to a precedent.
Right.
It's based on, we think it should stay, whereas 26.5, the last clause of 26.504C says, if you fall into this second category, at the expiration of the J51, you resume as if this section had never applied. And that's what we were discussing about Lucas. In this case, we said if that's the case, and if you were temporarily kept stabilized because of J51 receipt, now that the J51's
Are you
over,
arguing
you
for
should
us,
go back.
are you arguing for us to consider whether or not Lucas was properly decided?
Well, I'm arguing on that point, Your Honor, yes.
Thank you, counsel.